Welcome, everybody. My name is Beth West. I'm a shareholder here at Weintraub. I know many of you in the room, and I am the chair of the Labor and Employment Department. And we're so excited to be inviting people back in person after so many years of not being able to do this live and having to do it on a webinar. So welcome. I'm going to introduce the speakers. Next to me is Megan Bainbridge. She's my partner here at Weintraub. Katie Collins, my associate, and Jackie Simonovich, my associate, actually visiting us today from the San Francisco office. So did you drive up this morning, Jackie? Yeah. Thank you. And then James Katchmeyer, my partner, also in the L&E department, will be joining us. So we hope, right? And so we'll get started. I'm going to take the lead. We got a lot to cover, and I'll go over some housekeeping before we get going on the substance. And just know that some other people may kind of straggle in and join us as we get going today. I don't know if any of you, did you attend last week's part one? Okay, so part one was really concentrated on wage and hour. Years ago, we decided to separate our year in review update because usually we have so much to cover in wage and hour. We thought it was worthy to have its own seminar and webinar, and we added a few other topics to it. But this week we're doing other employment law developments. So before we get going, we have the webinar. People online, I don't think they can see me, but they can hear me. For those of you attending in person, be sure to pick up your RCI or MCLE, whichever one is appropriate, forms. Ramona is in the back if you have any questions about that, but we will be able to provide you with credit, continuing education credit. Webinar attendees and eBlast went out shortly before the webinar with a copy of the presentation along with information on how to request HRCI and MCLE credits. For those of you registered late yesterday or early this morning, note that a second eBlast will be sent out following the presentation with a link to the recording of the webinar. That eBlast includes a link to our labor and employment law blog, the California Employment News video, and podcast series, which we now have, as well as our firm's COVID-19 resource hub, which hopefully we're not needing to utilize as much as we were years past. Webinar attendees we're not going to use the chat function or raise hand functions. We welcome your questions in the Q&A function, and we will do our best to incorporate some of those questions during the presentation or if we have time at the end. And with that, I've introduced you to everyone, so let's get going. All right, part two of Employment Law Update 2022-2023. What are we going to talk about today? We're going to talk about leaves of absence under various statutes and some new legislation that impacts those. Harassment, discrimination, and retaliation, kind of our EEO bundle. Reasonable accommodations under ADA and California's FEHA. Settlement and non-disclosure agreements, covenants not to compete, and trade secrets. Arbitration, which is this nightmare where we kind of keep wondering what the heck is going to happen in California. And then the very nuanced subject, which probably doesn't apply to anybody in this room, but maybe it does, the ministerial exception to some employment laws. Okay, so I'm going to start us off with leave laws, and I'm going to get out from behind that podium. So we're going to talk legislation first, and then I picked a couple of what I think are key cases with some helpful information and news you can use for employers. Let's start first with AB 1041. You guys have probably heard the term now since the legislature ended its term in 2022, designated person, right? What does that mean, designated person? AB 1041 added designated person to both the California Family Rights Act, CFRA, and to the California Healthy Workplace, Healthy Families Act, which is California's paid sick leave law. But guess what? It's not defined the same under both. So under CFRA, a designated person was added to the definition of family member. Family member is the definition of those individuals that a otherwise eligible employee can take CFRA leave to take care of, right? If a family member has a serious health condition. Now, the definition of family member includes a designated person, which is defined as any individual related by blood or whose association with the employee is equivalent of a family relationship, okay? And that designated person would be identified by the employee at the time they asked to take the CFRA leave. So under CFRA, there has to be some representation by the employee that the designated person is related by blood or has some sort of familial relationship with the employee to take CFRA leave. And as a refresher, we know CFRA leave allows the employee, if they're otherwise eligible, to take up to 12 weeks, right, in the designated 12-month period. But under the Healthy Workplace, Healthy Families Act, that provision of the legislation didn't give it the same definition. It's any person identified by the employee at the time they're asking to take their statutory leave. There doesn't have to be a relation by blood or some familial relationship. It's just a person that the employee tells you is their designated person and they want to take sick leave to take care of that person, okay? Now, of course, we know under Healthy Family, Healthy Workplace, they're not getting 12 weeks of leave under that, right? They're getting the amount of leave either under the statutory accrual, 1 hour for every 30 hours worked, or they're getting the upfront floated 3 days, 24 hours, however your policy provides it. Now, an employer can limit an employee to one designated person in a 12-month period under both statutes. Okay, so once the person has told you who their designated person is and they've taken a leave under the particular statute, either CFRA or sick leave, that's it. That's their designated person for 12 months. They don't get to come to you and have another designated person. Okay, so be sure you update your policies now to include reference to designated persons. Okay, AB 1949 has now provided for statutorily protected bereavement leave. Always in California, prior to this legislation, if an employer had a bereavement leave policy, it was a discretionary policy that the employer provided. And they either provided unpaid time off for the death of a family member or sometimes paid time off for the death of a family member. But they were never mandated to do it. Now we're mandated, and actually AB 1949 has put the bereavement leave provisions inside of CFRA. It's part of the California Family Rights Act, but it doesn't have any of the same eligibility factors and time of service and all of that. Okay, it's different. Essentially what it says is the employee is entitled, if they're eligible, and I'll tell you what eligibility is in a minute, they're entitled to 5 days of bereavement leave under CFRA. Eligibility is they have to be employed for at least 30 days prior to taking the leave, right? For under CFRA, we know they have to be employed 12 months before they can have CFRA, other forms of CFRA leave. 5 days of leave does not need to be taken consecutively, okay? It can be taken intermittently, but the employee has to complete it within 3 months of the death of the person they're taking it for. And here is the limitation. Thank goodness they didn't say designated person here. There's a finite number of family members that they can take bereavement leave for: spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. Okay. Now, whether the leave is paid or unpaid depends on if a policy already existed with the employer prior to this law going into effect. If no existing policy exists, right, the employer had no bereavement leave policy, the statute says that those 5 days are unpaid 5 days of leave, okay, for bereavement. If the employer had an existing policy, but it provided for less than 5 days of paid leave, then the employee gets to take the number of paid days off that the employer provided, and then the remainder up to 5 as unpaid, okay? If the employer had a policy that provided less than 5 days of unpaid leave, then again, the employee is entitled to up to 5 days of unpaid leave. And in all situations, in all cases where the leave would otherwise be unpaid, an employee always has the right to concurrently use or ask to use any accrued and unused vacation they have available, PTO they have available, or sick leave. But concurrently, okay, they don't get to stack that on top of their 5 days of bereavement. Now, an employer can request documentation to verify the legitimacy of this leave, right? But you need to be very discreet and diplomatic about this. You have an employee who's grieving and going on bereavement leave, but you can ask for it only if you ask for it within 30 days of the day they take the leave. You wait, then you're not allowed to ask for it. And the kind of documentation that the statute provides for, I've provided for you here. This is all pretty straightforward. That would verify that somebody in fact has died. Like every law that provides a benefit to employees in California, there's an anti-retaliation, anti-interference provision. You can't interfere or retaliate against a person for exercising their rights under this new law. And you have to maintain confidentiality with respect to the use of their leave. And so if you've got a policy, you should update it so that it complies now with this. And if you don't have a policy, you should create one or work with your counsel to create one that complies with this new law. Okay, from the feds, we got a couple of things in 2022. We got this new fact sheet 280 and some FAQs to also answer questions with respect to FMLA leave for the employee's own mental health, serious health condition, or their family members. And really, this fact sheet and FAQ is just a reminder to employers that a serious health condition under the FMLA, and this is the same under the CFRA, is not always physical, right? If it meets the definition in the statute for serious health condition, but it's a mental health condition, it also qualifies an otherwise eligible employee to take FMLA leave. And so the DOL thought they needed to reiterate this because research is showing that what we've been living through in the last few years, right? Kind of the political social unrest and then a huge pandemic around the world, mental health issues are becoming much more of a concern, right? For employees and their family members. And so don't forget that an employee may be entitled to FMLA leave and CFRA in California. It would be consistent. And you can get more information on that link that I provided to the DOL. Okay, let's talk about some cases. So this first case, Roberts versus Gestamp, West Virginia, is very interesting. And I'm going to tell you the facts, we'll talk about it. And then I'm going to ask those of you who attended last year if you remember another case I talked to you about that seems to be contradictory. So this employee sued the employee. He was terminated. He sued the employer for violation of his FMLA rights, that the employer interfered with his FMLA. And here's what happened. Procedurally, the employer at the trial court level moved for summary judgment and won. But the employer appealed that decision. And when the appellate court reviewed the facts, the appellate court reversed. And here's what happened. So the employer in this case had a call-in number that employees were instructed and required to use if they were going to be absent from work, including if they needed to be absent for protected leave under FMLA, right? We know that. We've talked about that before. Employers are allowed to have that. This employee all of a sudden had to have an emergency appendectomy. Okay, he got very, very sick, goes to the hospital, emergency appendectomy. He's in the hospital, and what he does is he FaceTime messages, not FaceTime, I know I got that wrong. Facebook messages his supervisor and tells him what's going on, right? And I had this appendectomy, I'm hospitalized, I'm not going to be able to come in for a bit. And the supervisor continues to communicate with him through that Facebook messaging. So the employee also has somebody go and drop off a doctor's note at the employer's place of business saying he needs to be out for 2 weeks because of what happened. So he's out. Everything's fine. He doesn't get anything from HR, but he's out and nobody does anything. He then is cleared for work and he returns. But all of a sudden, about 4 days later, he's having a lot of pain. So he goes back to the doctor. Turns out he has a huge infection in his incision. And so he sends another Facebook message to a supervisor to tell the supervisor, I got this infection, they're putting me back in the hospital, and the supervisor doesn't reply to it. And so the employee gets hospitalized, sends another Facebook message to the supervisor doesn't reply to him. He's ghosting him, right? It's like radio silent. But what the supervisor does is then goes to HR and says, oh, this employee is absent and has been absent, and doesn't give the details, doesn't talk to HR about the Facebook messaging that's going on. So when the employee returns to work about 2 weeks later, HR comes in and says, you didn't follow our policy, you didn't call in, you're abandoning your job, you're terminated. Boom. So obviously, I already told you what the Court of Appeal did. The Court of Appeal reversed the summary judgment for the employer. And what the court said is, yes, we recognize that expressly in the regulations, it provides that an employee has to comply with the employer's usual and customary notice procedures. But what the court said is, just because an employer has one, and that is a presumption that that's the one that should be followed, that presumption can be rebutted if there's evidence that other forms of notifying the company can be shown to have taken place. And the court said, look, you know, those Facebook messages between the employee and the supervisor show that routinely this supervisor was communicating with this employee about his need to be on FMLA leave. And so that is going to be a usual and customary notice if the employer is allowing the supervisor to do that, right? So our takeaway is train your supervisor, right? And so if you remember last year, and this was when we were not together, we were in a webinar, I talked to you about the Munger versus Cascade Steel case. And in that case, an employee kept turning in doctor's notes for valid FMLA reasons, right? The need to be out. And those doctor's notes, the employee thought was sufficient to put the employer on notice that he had protected rights to take FMLA leave. But HR kept telling him, you have to use our third-party FMLA provider. They had contracted, which a lot of employers do, with an FMLA administrator. And the employee didn't do it. And then the HR provider says, you better do it or your leaves aren't going to be protected. And then a year later, he's out very, very sick, turns in a bunch of doctor's notes, and HR tells him again, you better, you know, you're required to contact and fill out the forms with our FMLA administrator. And the employee doesn't do it, and they terminate, saying that his leave is unprotected, his absence is unprotected. And the courts actually upheld summary judgment in favor of the employer, saying, yes, under that same thread, an employer can require that they use usual and customary procedures to notify the need to be out on FMLA. So how do we reconcile that, or how do we distinguish that? Really, the key is there was lots of documentation, right? Documentary evidence that showed that he was regularly told in this Munger case, you are not using our customary and usual system. You have to contact a third-party provider, and he was refusing to do it. But in this case, right, in the Roberts case, none of that was happening. The supervisor was communicating with him on what he needs. And so he reasonably believed, I am providing proper notice and my supervisor is authorizing my need to be absent, right? That's how we distinguish the two cases. Okay. The other case I thought was informative for employers. And I hope this never happens with you. And I'm shocked that it happened in this case if we had a trained FMLA lead manager in this case. But in this case, for a period of 9 years, this employee regularly went out on FMLA. Like every time FMLA was exhausted and he had a new 12 weeks, he was going out on FMLA, right? He took between 10 and 169 hours of FMLA every year for 9 years. So then in September 2016, he goes to the doctor. He's having serious mental health issues. And the doctor says, you are suffering PTSD. You need to take some time off. You need to take FMLA leave. So he goes to the FMLA manager to discuss it. Now, there is a dispute as to what was really said in the conversation between the two. But he claims that the manager said, you've taken serious amounts of FMLA. Don't take any more FMLA. If you do so, you're going to be disciplined. Now, would an FMLA administrative manager say that? Really? That's not who should be managing our FMLA system. Because on the records, the employee had FMLA leave available. He had it in his bank, right? It wasn't as if he was asking for something that he wasn't entitled to. She just looked at the record and said, oh my God, you're out all the time on FMLA. Don't do this, you're going to get disciplined, right? So the guy claims that he was so scared that he would be disciplined if he took FMLA leave. Instead, he took an early retirement from the agency, and then he turned around and sued for interference with his FMLA rights. Well, the employer says, what do you mean? We didn't interfere with your FMLA rights. You never even took FMLA, right? So they moved for summary judgment at the trial level and said he's never denied any of his FMLA. So under FMLA, this provision of the statute says that an employer may not interfere with, restrain, or deny the exercise of or the attempt to exercise any right provided under the act. Okay. And so what happened on appeal of that summary judgment was that the Court of Appeals said, look, the employer's argument that they didn't interfere with his FMLA rights because he never took it is not going to work when you actually look at this bolded language in the statute, right? Because it's an injunctive clause, interfere, restrain, or deny. And it also protects attempts to exercise, not just actual exercise of rights. And so the Court of Appeals said, look, the rights under the act would be significantly diminished if it permitted employers to actively discourage employees from taking FMLA leave, right? So that is a violation of that provision by telling the employee you really shouldn't take it even though you have it available. And so summary judgment in the employee's favor was reversed at the Court of Appeal. Okay, the third one is terminating an employee when they return from FMLA. Very dicey, right? Sensitive, no DIY or whatever, that's do it yourself, DIY. Don't do this at home on your own, right? Contact your counselor. But this is actually a favorable case for the employer. So the employee was this underwriting auditor, and she had had performance issues really since the start of her employment. Unfortunately, the employer was not documenting that contemporaneously and addressing it with her. And so she starts to experience some health issues. She actually takes a pretty long leave of absence that they don't designate as FMLA. They let her use sick leave, right? So she uses all of that. When she comes back, the supervisor decides to finally talk to her about performance deficiencies. And she says, you know what? Okay, I'm gonna do better. I'm gonna be more diligent. I'm gonna work harder. Thank you for bringing it to my attention. But 3 months after she returns, she asked to go on FMLA, and they have to grant it to her because they didn't designate her prior leave as FMLA. So it's waiting for her. And she met the 12 months, she met the 1,250 hours before she needed it. So she goes on FMLA. 4 days into that FMLA leave, the auditing department she works in, the other employees are finding more errors and problems in the work that she had worked on. And then all of a sudden, HUD knocks on the door, right? Housing and Urban Development out of the federal government, and says, we have discovered errors in some of the loans that employee audited in the prior year, and we're going to penalize you for it. You're going to pay a bunch of fines, employer, because of all these errors by her. So when that happens, the supervisor says, let's just terminate her, right? All these errors, everybody's discovering it. We're getting fined by the federal government. Let's terminate her. In this case, the employer does the right thing. It says, let's investigate first, and they investigate further. They're confident that it's more likely than not that she was the cause of those HUD errors. And so when she returns from FMLA, they terminate her employment. She sues, right, for, among other things, interference, retaliation for exercising her rights under FMLA. Again, employer moves for summary judgment. It's granted by the trial court. And in this case, the appellate court agrees with the employer, does not reverse summary judgment, because the court says, look, the statute makes clear it is a right of reinstatement statute, but an employee has no greater rights while they're on FMLA, and this is the same for CFRA, than they would have had they not taken the leave. And if this employee had been continuously employed and not on this leave of absence, the employer would have terminated her. Once that investigation was complete and they found out that all these HUD violations were in fact her poor performance deficiency. So it's a good case. It's a reminder that this is in the statute, right? That it's not a get out of jail free card to go out on FMLA or CFRA leave if we have other legitimate reasons to end the relationship. But I caution you, it's a very fact-specific analysis, and this favorable ruling is based on the facts of this case. So, you know, you're going to take action, especially if you're going to do it based on performance versus job elimination or reduction in force. You need to have good documentation to establish what those performance deficiencies, policy violations, or whatnot are, right, to support your action. And again, I don't think in this case I would do it alone. I would consult with your counsel, because it is very, you know, the inference is just the timing, right? She's engaged in protected activity, you terminate. That's an inference that you were motivated to terminate because she took the protected leave, and that gives rise to a retaliation. Okay. A couple of last minute things, and then I'll get off the floor because I always talk too long. These are for small employers. We have a California Paid Family Leave Grant program now, because CFRA now applies, and PDL has always applied to small employers, 5 or more, you know, the Pregnancy Disability Leave Act. And now CFRA applies to small employers. And that means if these small employers have employees going out on these leaves, and then these employees are applying for paid family leave benefits, right, under that partial wage replacement, there may be some kind of negative impact on the employer. So now there is a leave grant program, depending on the size of the employer, that the employer can apply for through the EDD to get some money each time the employee uses paid family leave when they're on CFRA or PDL, paid pregnancy disability leave. And I gave you the website link you can go to and get more information. We also have a California Small Employer Family Leave Mediation Program. This is being administered through what we used to always call, up until the end of last year, the FEHA, right? Fair Employment and Housing, not FEHA, DFEH, the Department of Fair Employment and Housing. And they changed their name to the California Civil Rights Department. So now you're going to hear us, it's going to take me a while. You're going to hear me refer to the CRD instead of the DFEH. But anyway, under this program, small employers with 5 to 19 employees, and the employee can choose to go through a mediation program with the CRD if there is a claim of a violation of the employee's rights under CFRA, right? If the employee says, the employer interfered with my rights or retaliated against me for taking CFRA, and files an administrative claim with the CRD is going to make mediation available. Both parties have to agree to it, but if they do, that mediation has to take place before the employee can file his or her civil rights or his or her civil claim for a violation of CFRA. And again, I've given you the link so you can get more information on that. Now I'll turn it over to Katie. Thank you.
Right arrow? No, is it
That one? Yeah.
Make sure we're using the right one here. So as Beth said, I'm Katie Collins. I'm an associate in the Labor and Employment Department. I'm going to talk to you today about the new updates in harassment and discrimination law. And the first one is actually what Beth just talked about. In July of this year, the DFEH decided to change their name to the Civil Rights Department to make everyone's life easier, I'm sure. So make sure that you visit the new website. There are new posters that have to be updated. Everything is the same in terms of the powers and authorities that the DFEH used to have. CRD is exactly the same, just a new name that everyone has to get everything updated for. It was just to capture, they said it was to capture the services that the department provides. And some things are still in the process of updating, despite the fact that this happened in July. I do know in creating this PowerPoint, I made sure you guys had all of the links to the updated required posters. So these are the required posters. They all have now been updated. I think the last one was just updated a couple weeks ago to include the new logo and the new name. So use these links to make sure that you guys are using the correct and updated posters. Maybe. There we go. And effective January 1st, there is the Sexual Abuse and Cover-Up Accountability Act. So previously under section 340.16, a person that had been sexually assaulted after their 18th birthday had 10 years to bring that claim, or 3 years after they reasonably discovered an injury or illness that resulted from the sexual assault. The Sexual Abuse and Cover-Up Accountability Act now changed that, and sexual assault survivors will be able to bring claims as plaintiffs in civil court until December 31st, 2026. So that's a pretty extended statute of limitations that these individuals are getting to bring their claims. Or 3 years from the bill's effective date is how it's stated right now. And those are for acts of sexual assault occurring on or after January 1st, 2009. And another big part of this is that this new act creates a 1-year revival period to bring a claim that would otherwise be barred because of statute of limitations. And that's where the plaintiff was sexually assaulted, one or more entities are legally responsible for damages arising out of the sexual assault, and the entities engaged in a cover-up. So that's why it's called the Cover-Up Accountability Act. And those people that are using that 1-year revival period will have until December 31st of this year to bring those claims. Additionally, it revives related claims for wrongful termination, sexual harassment, where the sexual assault is the basis of those claims. So not just the sexual assault claims, but the related claims as well. Importantly, it does not revive claims that have been fully litigated or that you've settled. So if you've done away with it, if you've already entered into a settlement agreement, if it's been litigated to its entirety, you don't have to worry about this. And the biggest takeaway here is kind of what we already know. Avoid any practices that could be seen as trying to silence people, trying to keep people from coming forward about any acts of sexual harassment or sexual assault. And then be sure that you're promptly investigating any mention whatsoever of this conduct in your workplace. And moving on to discrimination. So the Contraceptive Equity Act of 2022 amended FEHA to include reproductive health decision-making. And it makes it unlawful for an employer to discriminate against an applicant or an employee based on that reproductive health decision-making. And that's defined as a decision to use or access a particular drug, device, product, or medical service for reproductive health. It also requires as a condition of employment, or it makes it unlawful to require someone to disclose information related to their reproductive health decision-making. So make sure that you're not asking anyone questions, especially an applicant. I'm not sure why you would, but please don't what decisions they're making about their reproductive health. The biggest takeaway here, obviously, is that employee handbooks do need to be updated to make sure that you're including that in your basic EEO non-discrimination on harassment statements. And off-the-job cannabis marijuana use. I'm sure you guys have already all heard about this one. It goes into effect January 1st of next year, actually. So we're kind of ahead of the game here. It amends FEHA, prohibits discrimination against a person in hiring, termination, or any term or condition of employment for employees' use of cannabis and products off the job and away from work. That's an important part of this. You cannot discriminate against someone who's using marijuana off the job and away from work. Or you cannot discriminate against them for failing an employer-mandated drug screening for having non-psychoactive cannabis metabolics in their hair, blood, urine, or body fluids. So that's a lot to digest, but we have time, luckily. And if the employer wishes to punish employee for marijuana-related conduct, they must show that the employee was either in possession of or under influence of marijuana while in the workplace. So that's an important standard that you need to be able to meet if you're trying to discipline someone for marijuana use. Employers can still conduct pre-employment and reasonable suspicion testing and take action if test results show active presence as opposed to non-psychoactive cannabis in employees' bodily fluids. And this is not applied to building and construction trades or positions that require a federal government background investigation or security clearance or DOD regulation. What did you say?
I hope not.
Yes, we're not gonna let those people slide. And then the biggest takeaway here is that you need to reevaluate how you're conducting drug tests and screenings to ensure you can differentiate between off-the-job marijuana use and employees currently under the influence of marijuana. I assume this is going to need conversations with the people that you're actually referring these employees out to for those drug tests to make sure that they have new methods of conducting the test to differentiate. And then a new EEOC poster came out in October of 2022. It's called Know Your Rights, Workplace Discrimination is Illegal. And there was a previous one, it was called Equal Employment Opportunity is the Law. The only differences here are that it notes that harassment is a prohibited form of discrimination, clarifies that sex discrimination includes discrimination based on pregnancy and related conditions, sexual orientation, or gender identity. And then a key one here is that it adds a QR code so that employees can easily access that file. So I know we're seeing QR codes on more and more things these days, and it just makes it easily accessible. They can just use their phone, go to that link, and immediately file a complaint. So those are the biggest changes to this poster. And then just making sure it's posted in a conspicuous location where notices to applicants and employees are customarily posted. It's also recommended to be posted digitally. And this link will take you directly to it as well. And then pay transparency. This is a big area of questions for everyone right now. I know, trying to get in compliance January 1st. This is obviously aimed at curbing discriminatory pay practices. Beginning January 1st, employers with at least 15 employees are required to include a pay scale with any job posting. And they define pay scale as the salary or hourly wage that the employer reasonably expects to pay for the position. And if employers use third-party services to post their job postings for them, that doesn't mean that they don't get to comply with this. They need to make sure that those third parties are complying and implementing the pay scale as well. And while employers do not have to volunteer such information to existing employees, if existing employees ask the employer for that information, they must provide it. And that requirement applies to all employers regardless of size. So as to where the top one in terms of posting the pay scale only applies to employers that have 15 or more employees, the requirement to provide the pay range for current employees applies to everyone across the board. And then larger employers who currently file those EEO-1 reports will now be required by the second Wednesday of May 2023 to submit pay data reports to our new CRD. As Beth said, we'll all get used to saying CRD rather than BFEH. And those reports need to include median and mean hourly rate for each combination of race, ethnicity, and sex within each job category. And the EEO reports that were previously done spell out what those job categories are. And the reports will need to be filed annually by the second Wednesday of each May thereafter. The employers must maintain records for job positions and wage rate history for each employee until 3 years after the employment relationship ends. So making sure all of your personnel files are including information, which hopefully you're already doing, but information about what wage rates you have these individuals working at. And then failure to comply could mean fines of $100 all the way up to $10,000 for violation. Steps that we recommend taking. So and hopefully you've already well on your way since we're a couple weeks into January here. Determine pay scales for all current positions. Work with legal counsel to conduct privilege audits to proactively identify any pay disparities and determine if there are legitimate reasons for those. So looking at your pay practices in terms of pay transparency law is obviously designed to curb discriminatory practices. Getting a jump on that and looking at your pay scales, looking at how you're paying people and fixing any issues before it becomes a real issue is advisable. And then review all new job postings, obviously, to make sure they're compliant, whether you're posting them yourself or you're having a third party post those. And then incorporate compliance with the new laws into your training protocols. So for anyone that's responsible for putting up those job postings, for creating job descriptions, anyone in your workforce that's handling that, make sure they are aware of how to handle current employee requests. I know that's going to be a big part of this, because the person that creates job postings might not necessarily be the HR person that is dealing with your current employees who are asking those questions. So being sure that everyone across the board is trained. And then the Labor Commissioner recently, just a few weeks ago now, posted a series of FAQs that can be found at this link here. And those are very helpful. There were a lot of unanswered questions. I think when pay transparency law first came out, particularly around, I know I've been dealing with a lot of questions with piece rate and commissions. So these FAQs do spell out, if you're paying someone just by piece rate or just by commission, that does need to be in your pay scale. But if you're paying them an hourly rate or a salary, then that makes up the pay scale. So there are really important distinctions and things that hopefully will be helpful to you guys in this FAQ. And we're all learning as we go. This is one where I feel like more and more will come out as we go through this process and employers are learning. I know different workforces, it's more challenging, obviously, to create the job posting and then if they have people being paid in a variety of ways. Yeah, do you have a question?
Yeah, so the ability for them to request the pay scale if they're already employed. I got some nosy people who might just ask every position, or do they only?
It's for their position. It's for their position. Okay, right.
'Cause I got some nosy folks. Like,
They're just gonna start asking for a list.
Yeah. Like, this is moving on,
No,
it's
yeah.
just, you
The
know,
pay scale for the position that they currently hold. Yeah, exactly. I think an important part of that obviously is those nosy people though are probably gonna watch the postings that you put for other positions. They'll track them on the, you know, they'll have their things just looking for what they might be making if they were in a different
big
source.
source of concern for us too.
Really?
Now everybody's gonna know what everybody makes.
Right.
It's like, sure, if they're gonna take that time.
Right. And the important part of the, the
Yeah.
important part is it's a range too. So it's not like you're necessarily knowing what that person is exactly making. They might be on the bottom of the spectrum, they might be in the top of the spectrum.
Right.
So at least there is that range piece rather than knowing exactly each and every person's salary, because that would be a bigger concern. And then there was additional EEOC guidance issued. This is now COVID related. Hopefully we're moving out of the COVID era. This was issued back in March of this year. It's called the COVID-19 Pandemic and Caregiver Discrimination under Federal Employment Discrimination Law. And again, here's a link so you can access it yourself. This just makes clear that an employer may not discriminate against an applicant or employee on the basis of protected classes, obviously. But it talks about the fact that discrimination can occur even inadvertently. So if employers are making assumptions and decisions based on an applicant's or an employee's caregiving obligation due to the COVID-19 pandemic, that can be called discrimination, depending on what you're dealing with there. And then obviously with let me see if I can say this right, LGBTQI plus applicants and employees are also protected from caregiver discrimination based on sex. An important part of this is that the requirements that you put on people that do not fall under this category, they need to be the same. You can't all of a sudden create more stringent requirements for the LGBTQI plus category. And then you may not deny caregiving leave to an employee with same-sex partner based on sexual orientation or gender identity of the employee or employee's partner. And when we're talking about these assumptions, this would really, like I said, hopefully we're moving out of this era. I don't see many schools closed with COVID related things. I know we're all kind of moving on with our lives, hopefully, fingers crossed. But this would really come up where if two people were up for a promotion, you got a male and a female, and you don't promote the female because you assume that schools are going to close again and the female is going to have to take care of the kids who are out because of COVID. That obviously is discriminatory. That's making assumptions about who's going to take on the responsibilities of dealing with a pandemic, which I know we all were dealing with that at some point when we were on lockdown and right, keeping kids home from school, dealing with the quarantine periods every time your kid gets exposed to anything. So try not to make assumptions. Obviously, direct discrimination is one thing, but making those inadvertent assumptions, just make sure you're paying attention to your own analysis when you're thinking through why you're making decisions about it. And then the federal laws enforced by the EEOC do not provide employees with a right to accommodations to handle caregiving duties. So while this describes this inadvertent discrimination based on caregiving duties, that doesn't mean that you have a right to accommodate to handle caregiving duties. But other reasonable accommodation laws under the ADA and state laws still apply if an employee has a disability or medical condition that impacts the employee's ability to perform the essential functions of the job. So just always keep that in mind. Obviously, it's an ongoing conversation. It's a fact-by-fact analysis if you're dealing with someone that needs some sort of accommodation. All right, and moving on to retaliation. Is Beth?
Beth is gonna.
Oh,
there's
Couple
some-
questions. Yeah, there's some questions.
Oh, in the back.
that have been submitted that are on my section, so
Okay.
maybe it'll happen to you too.
Perfect.
And then I'll get out of the way and Megan will take over on retaliation. So Ramona's gonna read those questions, so we all have the benefit of discussing them.
Under AB 1041, if we limit to one designated person for 12 months, is that one person total? Or one person for 6 and could be another for CFRA?
Yeah, it's separate because each statutory entitlement is a separate entitlement, right? So CFRA is a completely separate statute from HWHF, the sick leave law. And so if somebody designates a designated person under CFRA, they get to, under this mandatory sick leave law, designate a different designated person, okay?
Next, for the bereavement leave, it says parent-in-law. Would that cover a grandparent-in-law?
Not according to the strict language of the statute. It says death of spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law.
And then FMLA and mental health, is a marriage family therapist considered a healthcare provider that is able to certify a mental health, serious health condition for an FMLA CFRA eligibility?
Yeah, so that is not a simple answer when you look at the regs, because the statute defines a healthcare provider as a doctor of medicine who's authorized to practice medicine or surgery, and any other person determined by the secretary of the DOL, Department of Labor, as being able to provide healthcare services. Then the DOL defines other person capable of providing healthcare services to include a number of others like dentists, psychologists, optometrists, chiropractors for limited purposes, nurse practitioners, Christian Scientists. But then they have this provision saying any healthcare provider from whom an employer or the employer's group health plan benefit manager will accept certification of the existence of a serious health condition. So I think that would have to be analyzed on a case-by-case basis. Clinical psychologist is recognized by the DOL, so maybe an MFT would also be recognized, but they're not called out specifically in the regs, okay?
If you're gonna deny it on that basis, you probably should be talking to.
You should talk to counsel, yeah, if you're gonna deny it. And remember that the courts don't want to see us playing doctor, so they don't want us questioning. Now, if it's fraudulent, if you get a chiropractor notice signed by a chiropractor that says that the person has PTSD or, anxiety disorder, I think then you could question, right? Because a chiropractor doesn't have that expertise. But, you really have to be careful when you're questioning the legitimacy of whether somebody can be a qualified healthcare provider.
For this, since we're on this topic, what about when employees say, I need a mental health day or something? Should we classify that under FMLA too?
Yeah. I think you have to, I don't know that that's enough information. Remember the regs say if you have enough information to know that it qualifies as FMLA, then you designate. Of course, we have that weird foster farm case in the Ninth Circuit that says they can ask you not to, but let's ignore that. I don't know that you have enough information from I need a mental health day that qualifies as a serious health condition. I hate to tell you this, guys, but serious health condition, it's got elements in the regs that you need to go back and look at, and you need to make sure, does it meet this? Are they seeing a doctor? Have they been hospitalized overnight? I think when they just have a mental health day, it's not going to meet the definition.
Right. Seriously. But also, are you put on notice that there is something else?
That's right. You may want to talk to them.
Look at the big
Is there
picture.
anything you need? Because it may not be FMLA. It could be a reasonable accommodation under ADA. It could be also, they need a mental health day. It could be they need to use one of their sick leave days.
Right.
If they have one too, right? So oftentimes the follow-up should be, is everything okay? What can we do? How can we help? And get them to see if they want to share more with you. And then you may know if you're now in some statutory landscape that you need to comply with. Okay, good, I'm done.
Hi, everyone. For those of you who don't know me, I'm Megan. As Beth said, I'm a shareholder in our group. I'm going to talk to you a little bit about retaliation and reasonable accommodation. So just a couple of things on retaliation. It was actually a surprisingly quiet year in terms of court cases, which is really where we see retaliation come up. That said, this is a big case. It's especially a big case for us lawyers. So it's a little legalistic and it may seem like it doesn't affect you, but it does. And I'm going to talk to you a little bit about that at the end. So this is the Lawson versus PPG architectural finishes case. This is specifically related to whistleblower retaliation. Everyone know what that is? Under 1102.5, it's essentially when an employee is complaining about a violation of law, a violation of statutes, that sort of thing. And so here we had Mr. Lawson, or PPPG Architectural Finishes. What they essentially do is they stock paint at Lowe's. And so Mr. Lawson, he was one of those individuals who essentially was doing the stock. If you ask PPG and their supervisor, Mr. Lawson wasn't a great employee, subject to performance reviews, disciplinary actions. There was some of that in the file, but probably could have been better documented. Around a time where it's undisputed, Mr. Lawson did make a complaint. He said his supervisor was mistinting painting. Not an expert in this. My understanding is what that means is that he was deliberately changing the tints of paint so that they would be returned. And so it, for whatever reason, it would fall on Lowe's and not PPG in terms of extra products. So Lawson complained about that, and then he was fired. Of course, if you ask PPG, nothing to do with it. It's totally based on his performance. The question in this case is what burden is used once litigation has commenced to determine whether or not it's the evidentiary standard. What in generally we have is called the McDonnell-Douglas burden shifting procedure. What that means is when we're doing litigation, there's a burden shifting test that is used to determine whether or not a case can be granted on summary judgment. It's also used by juries to determine whether who's at fault, essentially. McDonnell-Douglas is a federal standard, and what it says is this. First, an employer, in order to form what's called a prima facie case, they have to do three things in a retaliation context. They have to, one, prove that they made some sort of protected activity. Here, it would be they made a whistleblower complaint, which, as we said, is some sort of violation of law, etc. Two, after they have to prove they were subjected to protected activity, i.e. termination. Something happened to them in the employment context. Three, they have to establish some sort of causal link. If they can do that, then the burden shifts to the employer. All the employer at that stage has to do is prove that they had a legitimate business reason to make the decision they made. Here, that legitimate business reason would be he was fired because he wasn't a very good employee. Once the employer does that, the burden then shifts back to the employee to prove that that legitimate business reason, it's just pretext. It's not the real reason. It was just the reason, the excuse they're giving, but it's not really right. The reason they were really terminated is because of that protected activity. So that's what the evidentiary standard has been for a long time. What this case does is it says, no, that's actually not the evidentiary standard for whistleblowing complaints. Rather, it's this higher burden, where first the employee must show by a preponderance of the evidence that the employee engaged in a whistleblowing activity. What is preponderance of the evidence? 50% plus one. This, it's not a high standard. Once the employee does that, the burden then shifts to the employer, who must show by clear and convincing evidence that that legitimate reason was really why they took the action. Clear and convincing evidence, lawyers don't like that. That is much, much harder for us to establish. It's a much higher burden. So why is this case important for you guys and not just the lawyers in the room? If you have to understand, once this case is brought, it is way harder to get out of it. We have to do a lot more work. So what can you do? Contemporaneous documentation. When someone's making, not doing their job, that's when you write them up. For those performance reviews, those disciplinary actions, and you're doing it at that time. You're not waiting until some other action is taken. And if you're aware of some sort of whistleblower complaint and you want to terminate someone, or a supervisor is coming to you and say, hey, this person, they're good at their job, I think we should get rid of them. That's a good time to call your legal counsel. Don't do this alone. Whistleblower complaints, because of this higher standard, it's going to be a lot harder for you to get out at the end. So taking those steps at the beginning, training your supervisors, contemporaneous documentation, talking to your legal counsel, it's going to make a big difference. So next, we're going to talk about SB 1044, which is employee rights regarding emergency conditions. What this does is it prohibits employers from taking or threatening adverse action against any employee for refusing to report to or leaving a work site because the employee has a reasonable belief that the workplace is unsafe during an emergency. Emergency conditions defined as conditions of disaster or peril that exposes the safety of persons at the workplace by natural forces or fires, tornadoes and hurricanes. That's really effective, but the fires does. Active shooter situation, those sorts of things. What a reasonable belief means is it's what would a reasonable person believe subjects them to bodily harm, death. So if what this says that is if one of those emergency conditions is met, the employer can't require the employee to stay premises at work. There are, I'm not sure where you guys work, but there are some exceptions. Usually has to do with some sort of public service. Are you responsible for responding to those, emergency conditions, active shooter situations, that sort of thing? So if you think that might affect you, you can certainly contact me or look at the statute to see what those exceptions are. There are, probably a list of them. Notably, a health pandemic does not apply. So no, if your employee says, oh, according to SB 1044, I don't have to report to work because of the COVID-19 pandemic. That's not true. It also prevents employers from preventing an employee from accepting their mobile device. So, they have to be able to use their phone, contact their children, contact their spouse, whatever it might be. If they are refusing to report to work or wanting to leave because of this statute, they must notify the employer. They can't just leave. And the protection of law ceases when the emergency conditions have ceased. So I hope nobody ever has to deal with this, but if there's an active reporting, an active shooter, this doesn't apply a week later when they're asked to return to work. It only occurs when that actual situation has occurred. So what you should do going forward, review and update your existing policies to make sure nothing seems to directly refute this. Train your supervisors and make sure people who might have employees reporting to them that they need to leave the circumstances, just make sure that they know about this and so they don't get you in any trouble. Now I'm going to move on to reasonable accommodations. So the EEOC last year, and I think this year we're going to see a lot more of it. Their new thing is targeting artificial intelligence. You may think, what does this have to do with me as an employer? Well, technology can be a really great thing. There's all sorts of technology that's currently being used that essentially it helps employers make decisions on who to hire, on training, on promotions, that sort of thing. So specifically, it's talking about such things as automatic resume screening software, hiring software, analytics software, employee monitoring software, and worker management software. So anything in which you're using some sort of technology, artificial intelligence, to help you make decisions regarding your employees. What this is doing is it's telling employers, you can use these, but make sure they're getting used fairly and make sure they're not being used to disadvantage applicants or employees with disabilities violation. Notably, this guidance, this specific guidance, which we've been told more guidance will be forthcoming, it came just 1 week after the EEOC filed a complaint on this very issue. What does that tell us? That tells us EEOC is focusing on this, and we should note that if we are using any sort of artificial intelligence, that we're making sure to that it complies. So how are some of the ways this can affect you? The guidance specifically lays out 3 examples that they want you to pay attention to. First, by relying on the tool, the employer fails to provide a reasonable accommodation. So, do you have an applicant who are required to take some sort of typing test? Does that typing test, and if they're not able to do it because of some sort of disability, are they being distinguished? Because is that something you need to actually have a reasonable accommodation for? Second, this tool screens out an individual with a disability that is able to perform the essential functions of the job with or without accommodation. So again, focusing on the reasonable accommodations and whether or not someone's being screened out by not being able to meet that test. Here they talk about if a video interviewing tool analyzes speech patterns to determine problem-solving abilities. I didn't know computers could do that, but apparently there are ones that can. Does that screen out a person with speech impediments? Because it's different than what's expected. And finally, is the tool making any disability-related inquiries that would constitute a medical examination? So is it asking about medical conditions, accommodations, and restrictions, that sort of thing? So I think really what this is saying is be careful what you do if you're going to make decisions based on something other than, supervisors and hiring individuals if you're using any sort of computer program, and really think about and analyze whether or not it can be affecting anyone, whether or not it means to not. We're going to now talk about two quick legislation that was passed by the federal government. I'm going to tell you right now, most of you, that won't necessarily apply to you because you already have to do all these things. It's just essentially bringing up federal legislation to comply with California law, or what's already required under California. But under the Pregnant Workers Fairness Act, it essentially requires employers with at least 15 employees to provide reasonable accommodations to employees and applicants with known temporary limitations on their ability to perform the essential functions of jobs based on medical conditions associated with pregnancy. Under the ADA, pregnancy isn't a disability. It can be under certain circumstances, but being pregnant in and of itself isn't a disability. And under the Pregnancy Discrimination Act, reasonable accommodations aren't required. And so this is essentially kind of closing that loophole under federal law that would not require an employer to accommodate pregnancy-related disabilities. So again, for most of you, under FEHA, you're already going to have to be doing this anyway. But reasonable accommodations of pregnancy is required unless an undue hardship can be shown. You can't require an employee to take paid or unpaid leave because of a pregnancy unless if there's another reasonable accommodation that can be required, and retaliation is prohibited. Here under the Pump for Nursing Mothers Act, it expands existing employer obligations under the FLSA to provide reasonable breaks to express milk for a period of 1 year. This is going to be essentially bring up to compliance with California law and the California wage and hour. But you have to provide under Pump for Nursing Mothers Act a place for people to express milk. To do that in California, you have to allow nursing mothers to express milk on their paid breaks. If they desire to do that, that would be a paid break. And under existing law was amended to provide protection to exempt employees. So where they still have to be paid their full weekly wages, regardless of whether they take breaks.
What if you have a location that's very small and they're saying we need a specific room, an area for the mother to do that? How do you do that? You have only a certain amount of space.
Yeah, so under both this Pump for Nursing Mothers Act and California law, there is still the exemption for smaller employees, whether it would cause an undue hardship because of significant difficulty or expense. I will say this is a high standard. So if there's any place where they can take 15 or 20 minutes that has, the windows, doors can lock, no windows showing
You
that
literally have them in a storage room if that's all you
if
have.
that's all you have.
Okay. You're not,
It's not ideal,
but you're not.
but you're not required to go rent out a room to express, just for nursing mothers. both California and federal law will consider that undue hardship, especially for small employers. The smaller you are, the more that you're going to be able to establish a significant difficulty or expense. But the key is finding some private place for them to assess. Yeah. Beth earlier talked about DOL fact sheet number 2280 regarding mental health. This is just a reminder, just as it's a serious health condition, you might have to provide reasonable accommodations for it. So do make sure you're doing that analysis for mental health conditions.
Quick question. Back to the pump, do you still have to provide a refrigerator, smart refrigerator for the storage of the milk as well?
In California, that's, yes. And again, there may be that undue hardship in certain circumstances. I think that's in.
It can't get a refrigerator in the break room.
I believe it can be in the break.
But like
a shared refrigerator.
a shared fridge in the break room.
I would have to review it, but my understanding was yes, if that's all you can do, that you don't necessarily have to buy a small fridge just for expense. But I would need to push that. So we have Bryce versus Victor Valley Union High School District. Here, the plaintiff worked as a part-time substitute special education aide. She was then offered a full-time position doing the same exact thing. While she didn't have to take any sort of test, her physical exam to obtain the part-time position, they asked her to do that for the full-time position. They think that was a requirement of that position. She took the exam, failed it, and then she was terminated. She sued. The employer said, "Oh, we're cool. This test was an essential function of the job, or the test was completed in order to determine whether she could perform the essential functions of the job, and she failed it. We're cool." The trial court said, "Yeah, okay, that works." The appellate court said, "Wait, not so fast." They did that for 3 reasons. First, the appellate court said that yes, because here, the plaintiff never claimed she had a disability and never asked for a reasonable accommodation. So the court agreed with the trial court that the plaintiff had the burden of informing the district that she had a disability requiring a reasonable accommodation. But the court went a step further and said, yeah, she may not have done that, but there is enough information to create a triable issue of fact whether the district regarded her as disabled. So it was that where the district regarded her as disabled, it didn't matter whether or not she actually claimed to be disabled. That triggered the need to consider reasonable accommodations, and there is no evidence that the district had done that. The court further questioned whether running after students and passing this physical examination could really be considered an essential function of the job, where she had been performing it on a part-time basis, and that hadn't been reached. So really, this is reminding us that if it's an essential function for one portion of the job or a part-time position, it's an essential function of the job. And once someone's been doing that duty and has been essentially accommodated, if that really was an issue, you can't then later take it away and say, no, but you're not.
I have a question because this is we employ special aid students, but aides. We don't do the physicals right now, but we have come up with like some people that after the fact will bring something up, and so we do the interactive process. We were tossing back the idea that maybe, do you think it would be a good idea to have a physical before, like part of a pre-employment requisite, or leave it alone?
I would have you consult with legal counsel on that one if it's something you want to institute now. I think the concern, would you just be doing it for employees on a go forward?
Yeah.
That's going to be a lot safer and a lot cleaner than trying to take someone's job away that they haven't. But then there's always the question of whether or not, well, that employee who you already have employed, who has the same issue I have, they're being held to a different standard. So I'm not saying you can't do it, but you probably just want to make sure you're covering all your bases before.
I can see how in this case, it could open a can of worms.
Yes.
Yeah.
And really, the problem was here is that they were hiring part-time employees without requiring the test
Right.
that they require for full-time employees. They're doing the same duties the full time.
Right.
I'm just gonna go through these two cases really fast. They're both suitable seating cases, and they're not exactly reasonable accommodation. Those weren't present here. But this comes up all the time, and what these two cases tell us is these are such fact-intensive inquiries. Yes, here, same exact allegations that the employer didn't provide suitable seating as required by the orders in both this case and the next case. Here, in this, the LaFace versus Ross grocery case, the court, after a bench trial, a pretty lengthy one, found that Ralph had not violated the order requiring suitable seating. Because the evidence showed that even when wolves occurred where the employees were claiming they should have had suitable seating, they were required to do other things, moving about the store, doing restocking, that sort of thing. So that here the applicable wage order was not violated because they had these other duties that required them to do about. Here, in the Meta versus AutoZone case, the employer said, well, we did provide the chair. So, you know, in one case, the Ross case was saying we couldn't provide suitable seating because they needed to do all these other things and they couldn't have it just down. Here in the AutoZone case, saying, well, we did provide them, but there was no evidence they had ever told any employee where the suitable seating was, which if you're gonna have chairs available to your employees, I think you probably should tell them that. But so here where that there was not that express advisement that they could take a seat, whether that provided the seating had occurred was pretty vague. These are all fact intensive. You can have two employers doing the exact same thing, and depending on the facts of those cases and depending on how, you know, what sort of accommodation discussion is had, what sort of what you know, as Beth was talking earlier, the facts matter. And so just making sure you're doing these fact intensive inquiries is important. And finally, we have the Cower versus Foster Poultry Farms case. This is more of a workers' comp case, but what this case reminds us is the workers' comp board and civil litigation are two different things. In the workers' comp board and PHOP claims are different, and they must be analyzed separately. Here, Cower sued Foster Farms for disability discrimination and failure to provide a reasonable accommodation, among other things. Essentially, Cower was injured on the job, filed a workers' comp claim, and then was ultimately terminated. Cower first filed a claim of workers' comp alleging a 132A claim. That's essentially, I was treated differently because I filed for workers' comp. So it's a discrimination retaliation claim within the workers' comp outside of civil litigation. First filed that, second filed a civil lawsuit, and essentially claiming the same things. After the WCAB denied the Section 132A claim, Foster Farms filed a motion for summary judgment saying this is res judicata. The workers' comp board already said that we didn't terminate the person because of the workers' comp claim. The trial court balked that and said, yeah, that's true. Court of Appeal reversed, finding that while the WCAB on that specific retaliation discrimination claim, that may have been res judicata, the other claims of disability discrimination related, specifically the failure to accommodate an interactive process claims, those weren't wrapped up in the WCAB. They're two different things. So remember, when you have an employee making claims under workers' comp, you do what you need to do under workers' comp. I probably won't be able to talk too much of that. That's a whole world that I don't know what it is. But that doesn't mean you don't have the same obligations to accommodate, to engage in the interactive process and do all that. So make sure you're understanding that these are different and you got to do both. Any questions?
I have a quick question. In your department, workers' comp, you actually have a form to accommodate just position. So if you did that, you of course you sign it and then they go back to regular duties, would that suffice as far as not fall into the ADA and or other.
It could, it might not at the same time, depending on once they've been returned. Yes, exactly.
Okay.
Okay. And James did make it, so here he is.
Good morning, everyone. I'm James Catchmore. We're going to start with settlement and non-disclosure agreements, and we'll add in here severance agreements as well, because those are going to be more common with what you're going to be dealing with. Over the last couple of years, we've been telling you about new laws that have come into effect in California, primarily SB 331 and SB 820. SB 820 was enacted in 2018, and it was in reaction to the Me Too movement. There were news reports of people that were serial harassers. A CEO had harassed 10 employees, and people were wondering, how could this happen? How could we not know about it? Well, the reason we didn't know about it is because when the victim would bring a claim, there would be a settlement and a confidentiality provision that would prevent the victim from just talking about the harassment. So in response to the Me Too movement, they enacted 820, which said that in response to claims of sexual harassment, you could not put in a confidentiality agreement that prevented the victim from talking about the facts supporting the harassment. You could still protect the amount of any settlement, the identity of the victim if they chose to, but it was unlawful to restrict them from talking about the facts relating to the assault or harassment or sexual harassment. That took effect at the beginning of 2019. The legislature, as they're wont to do, said, hey, you know what, this is a pretty good idea. Let's expand it. So they enacted 331, which amended 2 code sections, civil procedure and government, to say, you know what, this isn't going to apply just to sexual harassment anymore. It's going to apply to any claim of harassment or discrimination. So in settling a claim for religious discrimination, gender discrimination, it's prohibited now to prevent or try to restrict the claimant from discussing the facts that underlie the claim of harassment or discrimination. As to the Code of Civil Procedure, it's going to apply to any claim, civil claim or administrative claim. You'll most likely have an attorney advising your company in those situations. They'll draft the settlement agreements and can address this. But the government code says you can't even do this in any agreement with the employee with regard to a job benefit or termination, so that if you're offering them severance, and you want them to, you know, here, we're going to give you 2 months severance, but we don't want you to talk about anything bad that happened while you were here. Or here, you know, we know the CEO was a little inappropriate at the Christmas party. Here's $1,000 bonus, sign this confidentiality agreement. These code sections are now going to prevent that. And it's more of a reminder, just because it went into effect last January 1st. So hopefully over the last year, you know, you've had a chance to go back and consider, you know, are you using old forms of severance agreements or separation agreements? You want to go back and see, do we have confidentiality provisions or non-disparagement provisions that may run afoul of these 2 new laws? And then turning to covenants not to compete and trade secrets. As you know, especially if you've attended this seminar over the years, California is very anti-non-competes. So you cannot, as an employer, restrict an employee's right to go work for a competitor or change jobs. There are 3 exceptions to that rule, and they all apply where rather than the focus is not on the status as an employee, but as a status of a seller of a business. So if I sell my business, I can be restricted from competing with the buyer for a certain period of time. The idea is they don't want me to sell the business and then set up shop across the street and then take all the business back, because that's not going to be fair to the buyer. So where there is a lawful exception, meaning the seller, then a non-compete will be enforceable. In 2008, the California Supreme Court held that just about every non-compete in the employment context will not be enforced. And so while this means that most non-competes are unenforceable, there are some exceptions that you need to be aware of, especially those of you that hire employees from other states. Other states do recognize non-competes. And just because you're hiring an employee into California, let's say from one of your big competitors that's set up in Texas, if they're subject to a valid non-compete under Texas law, you may be prohibited from hiring them in California. Not that a California court would enforce that non-compete, but the California court would say, sorry, this has to be litigated in Texas. And a Texas court will say, hey, California employer, you can't hire this employee because they have a non-compete. With the President Biden coming in, he signed an executive order in the middle of 2021 to promote competition. And one of the things he addressed there is he directed the FTC to explore the use of non-competes nationwide. And one of the impetus was there were a bunch of articles describing some of the circumstances in which employees were being subject to non-competes. And the most famous one was the Jimmy John's sandwich shops. If I was an employee making sandwiches at Jimmy John's, in my employment agreement, I agreed I would not work for a competing sandwich shop maker. And so people were like, this is crazy. These employees are making, minimum wage. And now you're saying just by accepting this job, they can no longer work in that general area. So that was kind of the impetus behind this. It had no immediate legal effect. It was more just directing the FTC to start giving some thought to this. Over the last year and a half, the FTC has been scrutinizing non-competes primarily in merger and acquisitions where one company takes over another. They may say, hey, we don't want your workforce competing with us, so we want all your engineers or all your salespeople to sign non-competes. The FTC has been looking at that. And the side, every year, I'm one of the last people to turn in my slides for this presentation. And every year Ramona yells at me on a daily basis to get my slides in. So this year, after days or weeks of yelling, right, Ramona? I turn in my slide that says FTC has not promulgated rules yet. And wouldn't you know, the next day, the FTC proposes new rules. And so I apologize, I haven't updated that. Ramona, if you had only given me one more day. So the FTC came out with new rules about a week ago. And what they're saying is it's going to be unlawful for an employer to enter into a non-compete with their employees. But not only that, will be unlawful for an employer to enforce a non-compete they may have entered into previously. It's only a proposed rule. There's going to be public comment. The U.S. Chamber of Commerce has already come out against this. There'll probably be legal challenges. We don't know yet what the final rule is. As California employers, this probably will not affect you, with the one exception that when you're hiring from out of state, if this rule goes into effect, it's going to make it less likely that an employee you hire is going to be subject to a valid non-compete. So to the extent you've had that experience in the past, this could remove that obstacle going forward. But again, we'll just have to wait and see how this transpires. I want to talk about two types of agreements a lot of businesses have. And the first one is an intellectual property agreement. We also call these inventions or invention assignment agreements. If you're in a type of business where you have employees that develop things, maybe they come up with new products or new processes, you want that work to belong to you. And so it's common, like in an engineering environment or a design environment, you have your employees sign a proprietary and invention agreement saying anything you develop while you're working for me belongs to us. You can't go out and patent it and then start selling it on your own. We're paying you, this is going to be our product. And you know, for years, these have been standard agreements. In Genesis Inc., the employer plaintiff sued a competitor and a former employee. And that employee had left, joined the a competitor, and within months of that employee joining them, they came out with a new product that was a lot alike the former employer's product. And so the former employer sued both the competitor and the former employee and brought a bunch of claims, one of which was, hey, employee, you breached the proprietary and inventions agreement because you didn't tell us you were working on this new product. And even though you were no longer in our employ, we should have some rights to it. The court disagreed, and the court said, by telling an employee that they can't develop or invent things after they leave your employee, that's a non-compete. And so we're going to strike it down under 16,600. So again, it's maybe for those of you that are using invention assignment or proprietary agreements with certain of your employees, you may want to have legal counsel review them to make sure that they're going to be limited. I think what the court was troubled by is the post-employment attempt to restrict the employee. You could restrict your employees for while they're employed with you. The question then becomes what happens after they leave your employee. And there was a similar issue regarding confidentiality agreements. These are a lot more common. Usually they're standard in employment agreements, employee handbooks, saying, you know, hey, employee, we're going to give you access to our business information, our customer list, our financial information. This is confidential business information. You're going to keep it confidential. We've been seeing employers getting tripped up in lawsuits, given how broad some of these agreements are drafted. And Moss Brothers, they sued former employees for, among other things, breaching a confidentiality agreement because the claim was you went and started soliciting your co-workers to join you at your new employer. You breached your confidentiality agreement that said you wouldn't do that. And the court said, no, we're going to throw that claim out because it's really in effect, a non-compete agreement. It's an attempt to get a non-compete because you're not claiming they're using your information to solicit. You're just mad that they're soliciting your employees. So it was held invalid there, and that claim was thrown out. A similar result in Aramark sued again for breach of a confidential information agreement. The confidential information was basically all our business information that's not trade secret. And the court said that is just way too broad. It's going to burden an employee who's going to work for a competitor or start a new business from figuring out, okay, what can I use and what can I not use? And the court held that that's also going to operate as a non-compete. So again, the takeaway here is, you know, if you have confidential information agreements that you've been using for years, you may be a good time to have them reviewed to make sure they're narrow so that they'll be enforceable and help protect your confidential information. Real quick, just turning to trade secret issues. There wasn't a whole lot this year, but again, a reminder, under California law, a trade secret is basically two things. It's information known only to your business that has economic value, i.e. gives you a competitive advantage. And two, that you've taken reasonable steps to protect the secrecy, confidentiality agreements, password protected computers, limited access. A few years ago, Congress enacted the Defend Trade Secrets Act, which basically created a federal law that basically mirrors California's law. Examples of trade secrets: the formula to Coca-Cola, the Kentucky Fried Chicken 12 secret ingredient recipe. For most of you, it's you're going to have trade secrets. It could be customer lists, who your clients are, who your customers are. how you do your pricing, who you give discounts to, your processes? Yes,
You're gonna have to update that. It's 11 herbs and spices.
oh, is it?
Yeah, I'm just saying if you wanna be.
Oh, we have
FTC
a
rules.
fried chicken aficionado here.
11 herbs and spices.
But, you know,
I'm- I keep it real.
Ramona, if you make a note, we have to update this as well. So when you're yelling at me next year, remind me of KFC. Reasonable efforts, the Coca-Cola formula, the myth is, it's written down, it's stored in a safe in a secured or in a floor of Coca-Cola's headquarters, and no one can access it but other, I think, 1 or 2 people. So that is how they show we've taken reasonable steps. The only notable case that I found in the past year was the Arthur J. Gallagher case. And what we find in trade secret litigation is the plaintiffs like to throw everything in the kitchen sink at the defendants. So they'll accuse you of taking trade secrets, but then they try to put all these other claims, conversion, you're breaching duties to us, breaching agreements. So in Gallagher, a bunch of employees left and joined the competitor in the insurance brokerage field. And Arthur Gallagher sued the competitor who hired them, saying, you conspired to misappropriate our trade secrets. And the court dismissed the conspiracy claim. And it basically did so on 2 grounds. Under California law, you really have to decide. You either bring a trade secret misappropriation claim or you don't. You can't tag on other claims to a misappropriation claim. So you either show that the employer conspired to you either show that employer misappropriated your trade secrets, or you don't. You don't accuse them of conspiracy. So we're going to get rid of that under California law. Under federal law, the court looked at the statute, said, look, Congress didn't put any provision in here that allows for conspiracy to violate its provision, so we're going to get rid of there. This comes up where you hire an employee, and unbeknownst to you, before they leave their former employer, maybe they download their client list or download some information that they think is going to be useful when they come over to you. The former employer may not be able to show that you misappropriated their trade secrets, and so they're going to look for other claims such as conspiracy. So the Gallagher case is it's closing a door to limit some of the exposure or liability the new employer is going to face when hiring this type of employee. And then we'll move on to arbitration. Any questions before I go? All right, other than the fried chicken recipe, I got that.
Keep it real.
All right, thank you, everyone. And then Jackie will be presenting on arbitration.
So I'm going to be presenting on arbitration and the ministerial exception today. There we go. Oh, wait, no. Okay, so the headline here is PAGA claims are still subject to arbitration. And I know some of you were at the presentation last week, and you heard about the Viking River case. So I'm just going to talk about how it applies to arbitration. And also I know there was some legalese, I know there was some legalese, and Ramona reminded me, so I'm going to try to break things down. So Viking River came out in June 2022, and it's good news because it held that there is a conflict between the FAA and the PAGA joinder mechanism. The FAA, the Federal Arbitration Act, was passed because courts were not enforcing arbitration agreements, and so it made it harder for courts not to enforce arbitration agreements. And the PAGA joinder mechanism, as you might know, just a reminder, is that there's an individual claim, and those are for violations that individual employee has suffered. And then there's these non-individual claims, and those are not necessarily violations that this individual employee has suffered, but the individual employee has standing to bring those non-individual claims because of their individual claims. So it's not like a class action where the employee is representative of other class members. It's a little different. And so it also held that the Iskanian, it overruled the Iskanian decision essentially. And Iskanian had held that you can't separate this individual claim from the non-individual claims. So you have an agreement to arbitrate, that employee agreed to arbitrate all their claims. But with PAGA, the joinder mechanism, the non-individual claim is, the individual claim is joined with the non-individual claims. It said you can't separate them. Well, this court held that saying you can't separate them is prohibiting the parties to freely agree to arbitrate claims, and it overruled that decision. And so essentially what happened is this plaintiff Moriana, it held that she lacked standing because she had agreed to arbitrate her individual claim, and that agreement, so because her individual claim gave her standing, once that was out of the litigation, then she didn't have standing to pursue those non-individual claims. And Justice Sotomayor noted in a concurring opinion that the legislature of California, they could modify the standing requirement for PAGA, and so which would to get around this decision. So essentially change what is required for a standing in a PAGA action. So since the Viking River decision, there has been a decision in the Eastern District of California, and it did follow the Viking River, it did follow the reasoning of Viking River. And so it compelled the plaintiff's individual claim to arbitration. And then it said it dismissed those non-individual claims for lack of standing. And the plaintiff did argue that the Supreme Court's Viking River decision was based on a mistaken view of California law, but the court rejected that argument. There we go. Okay. So moving on to California Assembly Bill 51. This was signed in 2019, and it prohibits employers from requiring employees to waive, as a condition of employment, their right to sue in court for claims arising under the Fair Employment and Housing Act and the California Labor Code. And it also says that employers can be liable for civil and criminal penalties for certain violations, and it applies to contracts entered into, modified, or extended on or after January 1st, 2020. So what happened? This AB 51 was passed. Then in January of 2020, a federal district court granted a preliminary injunction, and so stopping, essentially saying that it couldn't be enforced at that time. This went up to the Ninth Circuit. And so there was a decision in the Ninth Circuit on September 15th, 2021, and that case was Chamber of Commerce of the US versus Bonta. And it reversed the district court in part. It said that it reversed the preliminary injunction. So it said that there was not a conflict between AB 51 and the Federal Arbitration Act, which we talked about previously. And it specifically held this because there's language in AB 51 that it is not meant to invalidate an agreement otherwise enforceable under the FAA. And it also reasoned that these were pre-agreement conditions, so the AB 51 was not acting on the actual agreement. It did reaffirm the district court's ruling that the civil and criminal penalties were preempted by federal law, and that's because they were essentially punishing employers for entering into arbitration agreements. So the US Chamber filed a petition for rehearing en banc, which means just the whole panel. And then, so I told you all about this decision, but after the Supreme Court's decision in Viking River, the Ninth Circuit unexpectedly withdrew this decision So essentially you can forget what I just said. And, and then it granted another rehearing, panel rehearing. And so that is pending. So we, still have to see what the Ninth Circuit is going to say. The fact that they withdrew their prior decision suggests that will probably be different, but we don't know that until we get the decision. So what does this mean? It means because there was a withdrawal of the Ninth Circuit decision that reversed that preliminary injunction from the district court should still remain in effect. However, even after this decision is heard by the Ninth Circuit, there's probably going to be appeal to the US Supreme Court, and which means that it could be some time before we really know how this all plays out. But in the meantime, it seems like that preliminary injunction of AB 51 is still in effect. And now something I'm sure applies to everyone, the ministerial exception. So the ministerial exception essentially says that you can't have employment discrimination. You can have employment discrimination, retaliation suits against an employer. If we go back to Hosanna Tabor was a case in 2012, and this addressed the employment discrimination suits, which were brought by a minister of the church. Now, who is a minister is really a specific question. And the court didn't help us answer that question because it said, well, we're not adopting a rigid test. In this case, the plaintiff, she did have the title of minister. She did have significant religious training, and she did religious education. So it said, yes, under these circumstances, she is a minister, and so she cannot bring an employment discrimination suit because of the ministerial exception. And she can't do that because if we were to judge how the church is governing its ministers, then we're getting into religion. And as the state, we can't do that. We can't judge how the church conducts itself, how it decides who is a minister. Now, Our Lady of Guadalupe School versus Morrissey Baruth. So this was a July 2020 decision. And from this decision, we got that the ministerial exception prohibits discrimination and retaliation claims. These plaintiffs were different than the plaintiff in Hosanna Tabor because they were two teachers. They were at a religious school. They didn't have the title of minister, but the church held they're still considered ministers because they're in charge of religious education. So under this Hosanna Tabor language, they are conveying the message of the church, and therefore the ministerial exception applies. And really that conveying of the message of the church language is very broad, but that is because the courts are allergic to anything that has to do with religion because they're not supposed to judge it. So, and there was an open question after Hosanna Tabor on whether it prohibited harassment suits on behalf of ministers, which was answered by Christopher Orr versus Christian Brothers High School. This was a Ninth Circuit case from November 2021. And this was a Catholic school principal. He claimed he was terminated for a racially discriminatory reason, and he was subjected to retaliation and a hostile work environment harassment. So the Ninth Circuit held that the ministerial exception precludes harassment claims when they involve the evaluation, governance, or administration of a minister, which is essentially the church saying we can't judge how you are governing your ministers because that is a church function, that is not a state function. The court did note that there might be some harassment claims that are not barred by the ministerial exception, such as sexual harassment claims that don't involve employment decisions. But we have yet to see a case that explicitly holds this. Was just what's called dicta, so a note in the court's decision to kind of guide other courts later. There was also an issue with the employee handbook. The plaintiff argued that because of language in the employee handbook, the Christian Brothers High School had waived the exception, but the court held there wasn't an explicit reference to the Fair Employment and Housing Act, and the Christian Brothers High School did not explicitly say it would be bound by FEHA, and so therefore it did not waive this ministerial exception.
And a good thing, that case can also apply to everyone else, because when you have employee handbooks, make sure what you're putting in there actually applies to you. Because if you're making broader, trying to comply with broader laws that you don't have to, like putting in your handbook, there's a pretty strong argument that you need to comply with whatever, putting in your handbook. So if you are a smaller employer, with some of these, laws that apply to bigger employees, only if they don't apply to you, don't put them in your handbook. I think we have a couple minutes if there's any questions. Otherwise, Ramona has some things she would like me to talk about.
I have one about Severance. So we have a couple different states, and I have a person who works for Maryland in the state of Maine. Does not work in California, but his wife is pregnant, wants to know Severance apply. And there's some Maine language, in particular when you have remote employees, you need to know, just because we're talking base organization, if the employee actually resides and works in the other state, will Severance apply?
Well, it's going to depend on a lot of things. For instance, you're just talking about handbooks. Has that person been given a handbook that says secret advice?
I'll have to check on it.
Yeah, so there's, typically if you have a remote employee who, and this is becoming a lot more. So if you have a lot of remote employees, there may be different handbooks you want to give to them. But typically, if you can establish that that employee is employed in a different state, that there's not sufficient contact with California, they're not doing work that would be classified like in California, for instance, kind of thing.
So this is like an IT help desk. So we call them in case something happens with the ship, like reset laptops and etc.
Yeah, so arguably, you could argue, there's certainly, depending on the specific facts, it could be that they're not necessarily in contact with California to make it a California employee, but I would check on that. Have we already agreed to by getting policies that apply to their employment? So,
And then I understand we have the majority of our employees data and have a few that do work in California on occasion, and that is my understanding that would apply.
yes, if they have if they're in California, even a little bit California.
Thank you.
Does Weintraub Tobin have, I don't have any human resources. We have like a basic small business human resource book that we can fill in the blanks or.
I don't know, Ramona.
I'd like to see, but I'm just saying if it comes from our attorneys, it just looks more official.
Yeah, I mean.
Yeah, we could reach out to Lucas and Lucas can tell us.
Okay, well, I scared him just when I started asking.
They tried California. They tried California as a good resource too for small businesses.
Okay.
Yeah, and so like I know we do have like a form handbook that will specify small employer things, but what as to like an actual like paper or something.
And we discussed this from the last meeting. The man's walking off the edge there and we.
Yes.
No one seems to know that.
Okay. We don't have any say in that. No, I don't know, Ramona, do you understand?
We,
I think it's the end.
one small step for man, one.
Because most labor laws, they want to jump off. I mean, that's the reality.
20 people in California makes you want to.
Yes, California.
Yeah. All that's appropriate. Fair game.
Are there any other questions? We're waiting.
I do actually have one related to the handbook topic. So you mentioned having a separate handbook potentially for each state you have employees in. I have employees in 21 states. The bulk, yeah. The bulk of them are in California, and so we're currently revising it. And the plan right now is to indicate this is a California handbook. If you don't live in California, please see HR for the state specific things.
Yeah, so
And
there'll be
we
like a
would-
separate.
Right, and we would put that under the areas that there are differences, right, like CETRA.
Yeah.
Or. That's really the big one, but.
Yeah, and if you, so like, if you have a secret policy, make sure your policy says, if employed in California and eligible. All you have to put is that, language that doesn't
Okay.
just make it appear that it applies.
Well, so that was my question was, is it better to have separate handbooks? Or is what we're doing a disclaimer like that that says, there's exceptions, come see us sufficient?
Yeah, so I think what most employers that I see do is we'll have one handbook that applies to everyone.
Mhm.
And it will have that, and for certain policies, it will say that,
Okay.
if this applies to you.
Yeah.
And then there'll be supplements. So here's your Nevada stuff, here's your Oregon, here's your Washington.
That's what Shauna did for us.
It makes it easy. The only thing I would say is if you have a lot of employees. If you have a lot of employees somewhere outside of California and they see this huge laundry list of leaves that are available to California employees and you get questions, sometimes we'll say, well, let's do a generic handbook and do a California leave supplement so that people aren't going, oh, well, how come I don't get organ donor leave or whatever the case may be.
Recently,
When we have just a smattering of a couple employees here and there outside of California, it's pretty much easy to say, we're California based, our mass workforce is here. You just have 3 people outside of
So I can
California.
have like company specific.
Yeah, you can have like.
Geo, that kind of thing, and then
standard
for state
policy.
specific.
Yeah, and just do like a California leaves, supplement or something like that, because, but, most of your code of conduct and all that stuff, you don't want to have to repeat it, and then it gets really expensive when you have an attorney review it and have to review 22 different handbooks from start to finish, so this way we just know to look for, hey, here's your policies for California and other states. Just to tap on what Megan was thinking.
thank you. Anything else? Because if not,
Question on the last, that it's not really part of this reading.
we can look at it after and respond. Okay, so are these on here? Oh, yeah. Oh, California Employment News. Have you guys started listening or watching? It's on YouTube and you can find it on pretty much, I think, any podcast thing you listen to. So we try to keep them really short, just the kind of news you need to know, or to supplement our blog, which we still should be having regular articles on that as well. Our training, we have finally come up with our training schedule for this year. Our next one is waking up to discover your independent contractor was actually your employee. So that's going to be on March 15th. Do you have other? And then one on the risk of retaliation claims. Retaliation, I think, is one of the scariest parts. These are some of the hardest when it comes to litigation, the hardest ones to defend. So we're talking about that on April 12th. And then I guess our full schedule can be found on our website. And do you have copies, Ramona, somewhere?
Yes.
And they're up there. So if you have any additional questions, I think all of our contact information was on the first or second page of the handout, and feel free to contact us, and we are happy to answer any questions you have. And thanks for joining us.
Thank you.